Time is ripe. This is a session on drafting interlocutory applications in the civil procedure, and it will be a discussional point of it, where every person is allowed to comment one or another, give your experience in a law firm. If you ever encountered such an application, what are the nitty-gritties that a student ought to master when drafting such kind of an application, so that we clearly understand back at the practice part of it as compared to the theoretical part of it. So generally, I will start with the introductory part of it, where I will discuss on Order 38. So you can imagine so I'll start with Order 38 of the civil procedure, and Order 39 that governs arrest and attachment before judgment, a Mareva injunction. I'll also discuss on Order 40 on temporary injunctions and interpleader proceedings that are governed by Section 58 of the Civil Procedure Act and Order 34. Then we'll also do a recap of the previous presentations that we did, PI interlocutory applications being brought by notice of motion, and applications being brought by chamber summons, and even OS. We at one time had that discussion. So equal to a full kind of a webinar yenye complete from the word go. Now, nimesema it is engaging, feel free. We'll also discuss on third party proceedings that is governed by Order 1 all the way to Rule 15 to 22. Summary judgment that is governed by Order 36, and it should be distinguished from striking out under Order 2 Rule 15 and judgment on admission under Order 13 Rule 2. Remember, the examiner is very tricky. He will know that you don't know how to distinguish between those kind of applications. We'll also do various applications seeking leave. For example, leave to appeal, leave to amend pleadings, leave to issue a third party notice, or service outside of Kenya, or file a matter out of time. So that is the general overview of what we are going to do. And then add chamber summon and notice of motion application, CTC. What are the governing principles that we should expect? We should expect to talk about Article 51 of the Constitution on the right to a fair hearing, Article 159(2)(b) and D on justice without delay and without undue regard to technicalities, and Section 1A and 1B of the Civil Procedure Act being the overriding objective, and Section 3A on the court's inherent power, and Section 63 on the court's supplemental powers, and Order 51 on general procedure for applications and any specific rule that will govern a certain relief that we are going to seek before court. So expect the general form that is usually applicable. So unless the specific rule will prescribe any other form, an interlocutory application is ordinarily made by notice of motion supported by an affidavit. So a normal filing bundle will contain a certificate of urgency if appropriate, notice of motion, supporting affidavit, any annexures, a draft order. We have seen CLE questions telling students to draft a ruling, and at times even an order or a ruling on a preliminary objection, where you are expected to master various tests to give a ruling. Then at times you even see written submissions. These are seen in criminal litigation paper, where students were told to draft written submissions, and affidavit of service. Now, Order 51 Rule 13 tells us that an application and list of authorities should ordinarily be served at least 7 clear days before hearing. Ex parte relief requires a proper legal analysis. Okay, I'll also avoid many theories in this session, because the target is to understand what exactly happens on the ground. I'll also give my practical application that we have also borrowed from the law firm, so that it becomes more impactful to you. I'm avoiding theory as much as possible because CLE haitaki stories. leave alone the deposit of acquisition funds, we will have to revisit the same. So I will start with the first application on applications being brought under Order 40. And generally, we will start with theory part of it, then go to practice. I'll project the drafting. So a temporary prohibition. We start under Order 40, we have temporary prohibitory injunctions. What is the meaning first? So a temporary prohibitory injunction restrains a party from doing a specified act pending either inter partes hearing of the application, determination of the suit, or another specified event that you want the court to give a temporary prohibitory injunction. So it preserves the existing position. It does not ordinarily compel a party to undo an act already completed, because that would generally require a mandatory injunction. So what is the statutory basis of this kind of an application? We are moving court under Order 40 Rule 1, where it is applying where property in dispute is in danger of either being wasted, being damaged, being alienated, being wrongfully sold in execution, or being dealt with in a manner that may prejudice a party. Order 40 Rule 2 permits an injunction to restrain breach of contract or another injury relating to the same contract, property, or a right. So those are the preliminary points that you should now start having a look at. Now, whenever you're drafting any application, there is an applicable test that the examiner is looking to see whether you will be in a position to bring it out in your application. So the applicable test for Order 40 applications will be that the examiner is requiring the applicant to show, the word is must, a prima facie case with a probability of success, a likelihood of irreparable injury not adequately compensatable by damages, and if the court is in doubt, that the balance of convenience favors the injunction. So these limbs are generally considered sequentially, as it was decided in the case of Mrao Limited versus First American Bank of Kenya Limited and others. We also have the Giela versus Casman Brown and Company Limited, and we also have the Nguruman Limited versus Jan Bond Nielsen and two others. So if your paper appears to be lacking such kind of authorities on the applicable test that the examiner will be looking at, then you should know that you have not mastered this kind of an application. So a prima facie case is not established merely by presenting an arguable claim, because the material should show an apparently infringed right requiring an answer. Okay, so when you are doing this kind of an application on the prima facie case, because this application should flow in a way that you are showing how this limb has been met. So whenever you're framing your grounds, remember you're supporting your grounds based on this applicable test so that the court will appreciate your application. So take note, whenever you're discussing on prima facie case, you should not incline merely by presenting an arguable claim. You should not be taking an angle that, examiner, look, I have an arguable claim that needs to be discussed. That is not the way that the examiner expects you to go. The examiner expects you to say that this material is showing an apparently infringed right that requires an immediate answer or immediate action. Okay? Then, if you do that 1.4 on ex parte injunctions, under Order 40 Rule 4 continues to tell us that the court must record why delay would defeat the object of the injunction, and an ex parte injunction may initially issue only once for no more than 14 days. And 3, it may be extended once by consent or court order for no more than a further 14 days. So if a client comes to you and tells you, I had already obtained an injunction, it was ex parte, and then the examiner tells you that this client is approaching you on the 15th day. So take note that you can extend the same by consent or order of court for no more than a further 14 days. So that is the first advice that you'll be giving this client. So the order, application, and pleading must be served within 3 days, failing which the injunction automatically lapses. And the application should ordinarily be heard within 60 days unless extended for good reason. On the other hand, Under Order 40 Rule 6, an interlocutory injunction ordinarily lapses if the suit is not determined within 12 months, unless the court orders otherwise for sufficient reasons. So these are just mere theories, and now we will appreciate how such kind of applications are drafted. So draft number 1 was on temporary prohibitory injunction. Take note of how I have avoided the Republic of Kenya, the jurisdiction of the court, the parties, and now introduce the subject of the document being under the notice of motion. Take note that we are not cramming the provision. I want them to come out in a natural manner. That's why I started with the theoretical part. So this application is usually brought under Order 40 Rule 1, 2, and 4, and even Order 51 Rule 1, and Section 1A, 1B, 3A, and 63C of the Civil Procedure Act. So the applicant will be seeking the following orders. So these are the orders that the examiner will be looking for: that this application be certified urgent, that pending the inter-parties hearing of this application, the respondent, its servants, agents, or person acting through it be restrained from doing a certain act. Pending the hearing and termination of the suit, the respondent be restrained from doing a certain act, and the court directs that the status quo obtaining at this day be preserved and the cost be in the cause. Then the grounds, these are now lifted directly from the marking point that the examiner expects to see in every application of the best a student. So the grounds are that the applicant is having maybe an interest in that, appropriate interest in that property, or the applicant's right is evidenced by a certain title that you will annex in the supporting affidavit. On this day, the respondent now states the actual threat that is infringing your right, that is likely to infringe your right, and now that the applicant has established a prima facie case because you are identifying an apparent infringement and not bringing an arguable case before the court. And unless restrained, the respondent will do that act, okay? It's either alienate, demolish, or fundamentally alter the subject matter. And the resulting injury cannot adequately be compensated by damages because of this reason. So you give a brief explanation. Then the balance of convenience favors preservation of the present position, okay? So the suit and application were filed promptly without unreasonable delay. So generally, I'm giving you the meat as compared to telling you this is the form. Remember, we were told the CLE engagement, they don't look at the form. If you are told to draft a charge sheet, they will not look at the linings that what is the content that you want to protect before the examiner. So when it comes to Anton-Pillar orders, this is also a kind of a temporary injunction to prohibit, to give orders for inspection of a certain property or item. So an Anton-Pillar order authorizes controlled entry into specified premises, either to inspect, to take photographs, copy, take an inventory of, or preserve identified documents, and its object is to prevent the destruction or concealment of vital evidence. So if you are in a position where you have drafted such kind of an application before any court, there were mistakes that you ever did, you just feel free to tell us so that we also avoid such kind of mistakes whenever I'm projecting something and you feel, no, this is not something that I did in practice or what I was told by my senior. So let us bring the practical part of it as much as possible. So the legal basis of an Anton-Pillar application will be, depending on the case, the application may invoke Section 1A, 1B, 3A, and 63 of the Civil Procedure Act. And remember, the ground norm of the application is Order 40, Rule 1, 4, and 10, and Section 22 of the Civil Procedure Act, the applicable intellectual property statute, and the court's inherent and equitable jurisdiction. So take note that Order 40, Rule 10 will permit detention, preservation, and inspection of property, entry upon land or buildings, and the taking of samples or even observations. That's why we have invoked Rule 10 of Order 40. Okay, so what is the threshold? This is the most important part to an examiner. So the applicant, whenever you're seeking an Anton-Pillar order, okay, these are the grounds that you should stick to. So the applicant should establish that you have an extremely strong prima facie case that very serious actual or potential damage is likely to occur, and give clear evidence that the respondent possesses relevant material, and that there is a real possibility that the material will be destroyed or concealed if notice is given. Okay, and strict identification of the premises and material, proportionality, full and frank disclosure, and undertaking as to damages and appropriate safeguards during execution. Remember, these tests have been borrowed from various decisions, but it is not mandatory for you to say all of the tests because they are the key ones that the examiner is expecting to see. Have you clearly identified the premises and who is exactly in control of that kind of item or property that you want to be granted access to? So, what are the proposed prayers that you'll be seeking in this kind of an application? So the proposed prayers, you'll be structuring them as follows: that you as the applicant be heard ex parte in the first instance, because you don't want to issue a notice because this person will disappear. And the court appoints, you can even name an independent advocate as a supervising advocate, and that the respondent be required to permit the supervising advocate, accompanied by either an expert or representative, to enter the premises situated at that exact place for purposes of inspecting and preserving. Now, it is important, if it is in relation to various documents, you can give the exact documents, you can specify the goods, you can specify electronic records and even devices. And that the persons executing the order be permitted to inspect and photograph the specified items, prepare an inventory, make forensic copies of identified electronic data, and place disputed or privileged material in sealed custody pending further orders. So take note also to say that no forcible entry shall be permitted, that the respondent be entitled to obtain legal advice before compliance, provided that such advice is obtained without unreasonable delay, that the applicant and its advocate shall not use or disclose preserved material except for purposes of those proceedings and subject to further directions. So take note of how this kind of an application is trying to comply with the data protection laws, and that the application be fixed for inter partes hearing on a certain date. Now, remember, every application that you're doing, you're supporting it to the supporting affidavit, and now the supporting affidavit to this kind of interim relief that you are seeking before court, you must disclose the following. So you must disclose the exact cause of action, the evidence linking the respondent to the alleged wrongdoing, the precise material being sought for inspection, and how the applicant knows where the material is located, and the risk of destruction or concealment, and all adverse facts, previous disputes and applications, less intrusive alternatives, and why notice would defeat the application. So generally, if that kind of a relief comes this year, I'm confident that majority of us will have to explain on what we have projected before you, focus on the meat as compared to the general form. Now, there is also a blind spot where if you're not in practice, you don't know what a test suit is, you don't know how to seek or do an application for a matter to be considered a test suit if there is a series of such matters that are emanating from similar facts and similar facts and transaction. So take note that whenever you see an examiner, it can come this here maybe a mandatory question, because we saw discoveries and inspections being asked in trial advocacy. So you'll tell the examiner that you know this is primarily based in Order 38 of the Civil Procedure Rules. And the purpose of this is that a purpose of a test suit is that it allows one suit to determine issues that is common to several similar suits, while the remaining suits are stayed. So you can have a 5 marks question telling you to discuss now the advantages of a test suit. So the advantages is that you are avoiding repetitive evidence across all matters, you are reducing costs, and you are preventing inconsistent judgments, and you're saving judicial time and even facilitating uniform settlement across all those matters. So those are the benefits of why it is important to consider one matter as a test suit and let that matter maybe determine liability, then it will apply across board in all other matters. So Order 38 Rule 1 where 2. Yes, Mr. Chedik?
So Order 38 is towards the principle of sub judice.
No. Sub judice is it section 6? We have section 6, sub judice, section 7, res judicata. Okay, I see your argument. You don't want a situation where okay, nimekupata. In practice, maybe a test suit also prevents a sub, but we can't say sub judice because hizo matters ziko independent, ni venye ziko na similar issue, but sub judice ni same parties, lakini sasa matter pia ina run in a different forum. No, with a court with concurrent jurisdiction to hear the same issues. So hiyo iko far-fetched kidogo, but here we want to prevent inconsistent judgments because I don't see a situation where ukikosa kufanya application for a test suit, automatically then you will be faced with inconsistent judgments. It is to your detriment, in fact. You will use a lot of cost and time, but I don't see where you'll be told that matter is sub judice because they are different parties. Good. So we have seen the benefit of why we are doing this kind of application. Then Order 38 Rule 1, where 2 or more plaintiffs have instituted separate suits against the same defendant and could have been joined as co-plaintiffs under Order 1, the court may select one as a test suit if the issues are precisely similar. Okay, and notice must be given to all affected parties. So this is now the angle. Maybe Mr. Chedik, you can say the court can inherently also in its own motion say, because you are seeing same plaintiffs and they have different suits against the same defendants, we can now combine under Order 38 Rule 1, where one plaintiff has instituted suits against, okay, this is now Order 38 Rule 2, where one plaintiff has instituted suits against several defendants who could have been joined. A defendant may seek a stay of their suit pending determination of another suit if the issues are precisely similar. So, Mr. Chedik, now these are the issues to do with sub judice pursuant to now what you are suggesting. And matters to determine is that the applicant should identify. Now, this is the preliminary check that you should know. Have you identified all affected case numbers? Have you identified the parties? What is the common cause of action? The precisely similar factual and legal issues? The best suit suited for trial? Any unique issues not covered by the proposed test suit? Prejudice, if any, that can be suffered from a stay, and how the result will be applied to the stayed suits. So when you're giving these, when you're doing this application to court, you must tell the magistrate or the judge, look, we have a series. Now the judge will tell you to list down the numbers of those matters and a note down in the proceedings, so that all those matters will now be stayed. Then you will move court using now a proper application to select a test suit. How will you draft it? Remember, I've said keep the titles constant. Remember what the CEO of CLE said. They wanna face a situation where students ni kama they are lazy to draft the initials of a case. So he said, instead of saying as appearing in a notice of motion, it will cost you nothing if you just repeat the heading so that you go in a professional manner, because people who are marking those things are advocates. So application to select a test suit is brought under a notice of motion. Now this is brought under Order 38 Rule 1 and 2 and Section 1A, 1B and 3A of the Civil Procedure Act. And the applicant will be seeking orders that case number and case title and number, the identified one that the factual matrix will give you, be selected and tried as the test suit, and all further proceedings in the following suit be stayed pending determination of the test suit. So you will give the list in alphabetical order, and that the parties in the stayed suits be bound on the common issue determined in the test suit, subject to direction concerning any individual issues, and that the court gives direction on the treatment of liability, causation, individual damages, and even cost, and cost being the cause. So remember, in a notice of motion, after you have said the orders that you'll be seeking, the next thing is to say the grounds upon which you are basing your application upon. you will tell the court that the suit arises from the same accident, transaction, or publication in given event, and that they involve the same defendant and even common defendants. So the issues of liability, either interpretation or validity, are precisely similar, and that the plaintiff or defendants could have been joined under Order 1, and that separate trials will duplicate witnesses and documents, and there is a risk of inconsistent determinations. And now the proposed test suit contains the fullest factual and evidential record, and that no party will suffer unfair prejudice. So take note of an NB there, that substantially related matters is not always enough, because Order 38 requires the issues to be precisely similar. So don't fall in the trap of saying that these matters appear to be substantially related. That is different from the issues are precisely similar, because at the end of the day, no court will want to issue conflicting judgment against another one. Now, we also have Mareva injunctions and attachment before judgment. These are also interlocutory applications. And a Mareva injunction, the nature of the relief that you'll be seeking from court is that you intend the court to issue a Mareva injunction to freeze identifiable assets to prevent a defendant from dissipating or removing them so as to frustrate a future decree. So its purpose is not to do the following. It is not to punish the defendant. It is not to compel early payment. It is not to give the plaintiff priority over creditors. It is not to obtain, yes, Mr. Pluto, res gestra is the name. Okay, res gestra is the name in test suit. Mr. Pluto, hapo unaweza mtu tueleze maneno.
Sorry, Victor, I mean, like in a test suit application, you have to show the suit, you have to prove to the court that the facts of the issues arise from the similar transaction. For instance, in a road traffic accident, we have one vehicle carrying different people, and those passengers sue the driver of the vehicle. You see, now res gestae there arises, and res gestae simply means things done in the same transaction. Therefore, we'll be proving to court that for the test suit, we are going to work, should only serve the purpose of, for instance, the liability alone. Issues like quantum, that will be now for later. But for the purpose of liability, later the test suit cover all the suits. So the res gestae simply means things done in the same transaction.
Thank you. Evidence law. Thank you, Pluto. Now, Mr. Pluto Inaka, you have one or another interacted with that application. Is there any mistake that you have ever done and you have ever been corrected by a senior?
Unfortunately, no. And again, I've never made such an application because my seniors usually do oral applications for such applications. So basically, one error that arose in some while back is we didn't include one of the cases to be covered by the test suit. So basically, you have to include all the cases, because the moment you omit one in that application, either oral or written, it means that the test suit won't cover it, and it will go for full hearing on its own basis.
Thank you. So those are the kind of discussions that I want us to have, because when I remember in my first year kwa law firm, ni kama nilibreach all kind of applications in a civil litigation paper. So nikikutana na moja nilifanya, I'll make sure ni may bring it clearly. Even in probate, when I was doing the session on all applications in probate, nilikuwa nasema hapa, I remember nikifanya hivi na hivi na hivi. So we also learn through mistakes. So thank you so much, Pluto, for that. So the purpose of a Mareva injunction is not to punish the defendant. It is not to compel early payment, nor give the plaintiff priority over creditors, nor even obtain security merely because the plaintiff fears non-payment, okay? Nor prevent ordinary legitimate business dealings without evidence of dissipation. So what is the statutory basis? Order 39 Rule 5 applies where the court is satisfied that the defendant, with intent to obstruct or delay execution of a possible decree, is about to dispose of all or part of their property, or is about to remove all or part of the property from the court's jurisdiction. So take note of it's either all or part of their property. So the applicant should ordinarily specify the property, the estimated value, and the conduct evidencing the relevant intention. And the court may now direct the defendant to show cause or furnish security and may order conditional attachment under Rule 6. Attachment may follow where the defendant fails to show cause or furnish security. Now, a Mareva threshold. Whenever you're doing any application on Mareva, these are the marking points. That you should show a good arguable case, that you should indicate to court that the defendant is within the court's jurisdiction or properly amenable to its process. So if the examiner wants to catch you, they will tell you the defendant is in Nairobi, but the defendant is currently residing in Nairobi, and he wants to transfer that kind of property to maybe it's a car, apeleke Uganda, and now you want to seek these orders from a court that is based in Meru. So automatically if you see that, alafu unaenda kukimbia hapo, umeambiwa advise this client, alafu ukose kusema that the defendant is within, he must be within the court's jurisdiction. So maybe mtu atatuambia what mistake he did wakati alifanya this kind of application, alafu that defendant is not within the court's jurisdiction. What happened? So, or properly amenable to its process, and you should even show the existence of identifiable assets, and it is a real and not speculative real of dissipation. Okay, and you should show that there is a connection between the anticipated dealing and an intention to frustrate enforcement, and there is a balance of convenience and proportionality between the frozen assets and the claim and an underlying as to damages. So the relevant authorities are as follows before your screens. Now, when doing this kind of an application, this is how it is structured. Okay, it is being brought under notice of motion, and specifically being brought under Order 39, Rule 5, 6, 7, 9, and Order 40 because it's an injunction, Order 51 under notice of motion now, and Section 1A, 1B, 3A, and 63 of the Civil Procedure Act. And now the applicant will seek the following orders. 1. That pending the inter-parties hearing, the respondent, its directors, servants, or agents be restrained from transferring, withdrawing, charging, selling, or otherwise dissipating the following assets. Why are we listing the assets? Because it is one thing that we must show. We must indicate the exact asset that we are afraid of. And now, pending determination of the suit, the respondent be directed to furnish security in the sum of this amount. Why are we saying for security? Because we saw the court can tell the defendant to show cause, and if he fails to show cause, he can be directed to furnish security in a certain amount. And then the respondent be directed to appear and show cause why the property specified in the application should not be attached before judgment. Okay? In default of furnishing security, the property be conditionally attached to the extent necessary to certify a possible decree, and that the order shall not prevent payment of reasonable ordinary business, legal, and living expenses subject to disclosure and stated limits, and that the applicant gives an undertaking as to damages and costs be in the cause. So those are the orders that you'll be seeking in such kind of applications. So it is very rare for any kind of a tutorial to go to the extent of giving you the meat. They only give you the model that you use to approach court, and then the exam comes, you don't even know the meat that will include in such kind of applications. Now, we have talked about Order 39, Rule 5, 6, 7, 8, 9, and Order 40 on Mareva injunctions. Then, in this situation, Order 34 will govern the procedure. And the form that you will be using, if there is no pending suit, you will use an originating summons. Is this applicable here? Is this applicable? Unajua was nimetoka from the application, kuna interpleader proceedings. Okay, is it jumping all the way to the other side? Okay, let me begin. Okay, yes. Nimeona kitu nasema. Now, we are under a different kind of an application. And this kind of application is known as an interpleader proceeding. So kwanza malizana na hiyo Mareva, we have done Mareva, we have done hiyo ingine ilikuwa inaitwa Anton Pillar, we have also done a test suit. Okay, under Order 38. So hapo kwanza tumeshika the basics. Now we are going into an interpleader proceeding. So the meaning of this is that an interpleader protects a neutral stakeholder facing competing claims to the same either debt, sum of money, movable property, or immovable property. In that the stakeholder is the one asking the court to determine the rightful claimant and discharge the stakeholder from liability. And statutory basis of this is that under Section 58 of the Civil Procedure Act, interpleader is available where? Now, these are the scenarios where interpleader will arise from. So where two or more persons claim adversely to each other, where they claim the same debt, money, or property, the stakeholder claims no interest except charges or costs. The stakeholder is ready to pay or deliver the subject matter to the rightful claimant, and no existing suit can adequately determine all the competing rights. Okay, so an interpleader, let me repeat that because at times the examiner atakuuliza, you also suggest to the stakeholder his rights, because watu wanaonanga ni kama stakeholder anafanya charity work by bringing this kind of an application. Take note that the stakeholder claims no interest except charges or costs. Okay, now there are two people claiming adversely against each other. They are claiming against one thing, and that the stakeholder is ready to pay. Once you master this theory, now doing these kind of applications, itakuwa very easy because this will just be lifted to your story, and that no existing suit can adequately determine all the competing rights. Order 58 of the Civil Procedure Act tells us so. Then, if you now move across board, Order 34 will be governing the procedure. Now, this is where you are told, in as much as we don't want you to capture the form, but at times you can have a pending suit, and at times we can have a suit that is pending in court. So take note that if the examiner tells you to do an interpleader application and there is no pending suit, you approach court using an originating summons, because that is directly captured in Order 34 of the Civil Procedure Rules. And if a suit concerning the same subject matter is pending, you do a notice of chamber summons in that suit. Have I captured the same? Summons in an act for chamber summons, and notice of motion, a fully notice of motion. Now, the available orders that you'll be seeking is that the court may either require payment or delivery of that item into court, discharge the stakeholder, substitute a claimant as defendant. The court may frame and try an issue between those claimants. It can also determine the matter summarily where appropriate. It can order sale or disposal of the subject matter and award the stakeholder cost or a charge over the property. So none of those notes were applicable to an interpleader proceeding application. Now, the material affidavit evidence, so the affidavit now that you'll be using to attach inside this kind of an application. Take note that I have drafted where you are approaching court using originating summon and a chamber summons, even the parties of how you will capture them. So in this kind, this affidavit, the same way when reaches a certain trend, I start with the right side, then go to the left side, because this appears to be the final document. So take note of the right side where we have interpleader through originating summons. This is where you state the jurisdiction of the court, which case in the matter of Section 58 of the Civil Procedure Act and in the matter of Order 34 of the Civil Procedure Rules, between who is the stakeholder. The stakeholder is the one having the property. He will be the applicant, and the first claimant will be the first respondent. So people who are fighting over that property and or movable property. Second claimant will be the second respondent. Now, the document that you are reaching court, you are approaching court with is an originating summon. We have seen in the best performed papers, this part scores a 1 mark because you have clearly understood what exactly you are doing before court. So let the respondent attend court for determination of the following questions, and which respondent is entitled to identify money, property, Now you're telling court the questions that you want court to determine, that you are focused on which respondent is entitled to a certain property, whether the applicant should be permitted to deposit or deliver the subject matter into court, whether the applicant should be discharged from liability upon such deposit or delivery, whether the respondents should be restrained from separately proceeding against the applicant in respect of the same subject matter, and which respondent should bear the applicant's cost, and what further orders are necessary for determination of the competing claims. We were told that in originating summons, the factual matrix is a straightforward situation, and you are not introducing complex nature or issues that the court is not likely to determine. So take note that you'll convert the words which, whether, etc. to now the appropriate language to use before court, that you'll find a way. This is just a mere meat that I'm giving you. So maybe anyone who has done such kind of an application can give us the words to use so that you go very substantive. Who amongst us have ever done an originating summon for an interpleader proceeding? Me search from my laptop sina. Any person akonayo anaweza project who has an interpleader proceeding so that we see the language. Unajua si mzuri nakuja na kuonesha in a summarized manner. Any member? Ringera, hujaifanya interpleader?
I have, give me a minute.
Okay, thank you. Let us wait so that we see. Yes, Pluto?
Yes, thank you. Maybe I can just read one naiona hapa. Can I?
Yes.
Okay. Anasema hivi. Kuna the caption itself, in the matter of delivery of possession of container number that and that, the applicant is Marlene Cargo. Then you have the respondent, the first respondent, who is Marlene. We have the plaintiff. Alafu nasema originating summons. Let Mwendwa Jose and Mwanaisha Boke appear in court for determination of the questions that the court issues the orders that the court to determine who amongst the two parties mentioned here and above is entitled to that possession of the container. The court to determine who amongst the two parties shall be liable to indemnify the plaintiff, the cost and the charges of the importation of the said container. And then the court to determine the cost of this application. Okay, ni just an application nimeiona online. It's done iko sawa. For the reason that naona kwanza wameweka plaintiff instead of an applicant and a respondent. But basically, my understanding of interpleader is that the wording should be let all concerned parties attend the Honorable Court with 4 chambers for determination of the following questions. For instance, whether the first respondent is entitled to the ownership of vehicle number so and so, and whether that and that. I mean, just determining who amongst the two people have the possessory rights or should be declared the owner of a certain suit or property which is in contention. Yes, I think that the wording is let all concerned parties attend the court attend the Honorable Court in chambers for determination of the following questions. then you just derive them, you just write them down, then you must support it with an affidavit. Alafu, I think the court has inherent power to convert that particular originating summons to a plaint whenever the issues are contested and they may require quash evidence.
Wow, thank you, Pluto. Brian, you are looking for something?
Okay, let me share my screen very quickly. So we are doing interpleader, right? We are looking for interpleader.
Yes.
So I have one here from the drive. I'll also share the link to this drive. So I'm not sure who compiled this Kingmaker drive, but drive iko tu sawa. I will share the link in a few. So they are bringing it under a certificate of agency. Here, as Pluto has noted, should be applicant and respondents.
I have a question there. Na ni important to address hiyo mambo ya plaintiff na defendant. Maybe Pluto, because we don't have any other matter before court, no subsisting matters, then the parties should be plaintiff and defendants, because tutatumia applicant kama kuna subsisting matter hapo kwa chamber summons. Is that the nini?
No, I don't think that's the position, because originating summons is basically an application which is more advanced. So it will be an applicant respondent, not a plaintiff. A plaintiff can only arise wakati kuna a plaintiff anafaa kuwa tu kwa plaintiff peke yake actually. Haizi kuwa anywhere else.
Thank you. Those are the nitty-gritty zenye nataka ziendelee ku come out. So Ringera, you can proceed.
It was noted, we shall be having an applicant and a respondent. So we're bringing it under a certificate of agency in the Republic of Kenya, in the High Court of Kenya at Nairobi, Milimani Law Courts. Civil case number 1474 of 2000, in the matter of civil procedure, Lost Bank of Africa Limited, the applicant versus the Wherever African Development Bank, the first respondent. We have the second respondent, third respondent, and fourth respondent. And a certificate of agency, IP advocate of PPP, Kababe, and PPP certify that the hearing of originating summons hearing is urgent, in that there are conflicting claims to the monies held by the plaintiff by all four defendants and conflicting orders of the court, together with threats of contempt proceedings against the plaintiff. Dated at Nairobi this day of March 21. Then we have your jurat and attestation. Then the Republic of Kenya, we have your originating summons drafting in the High Court of Kenya at Nairobi, Law Courts, civil case number dash, Bank of Africa Limited, the applicant versus the African Development Bank, the first respondent. You have the second, third, and fourth respondent, an originating summons under Rule 2, under Rule 3(2) of the High Court vacation rules, and the 37 of the Civil Procedure Rules. Let Wherever African Development Bank, PPP Kamis, PPP Limited, and Zimbabwe Bank of Kenya tell the judge in chambers on 28th day of March at 10 o'clock in the afternoon on the hearing of an application by the plaintiff Lost Bank of Africa Limited for that. This application we had during the court vacation. The above defendants do appear and state the nature of and particulars of the respective claims with the subject matter in dispute, namely the sums of US dollars, these and US dollars, this held in accounts, this number and this number at the plaintiff's bank, and maintain or relinquish the same and abide by such order as may be made hereon. 3. For such orders as the court may deem fit as to the cost of this application, on the grounds that the defendants are making claims to the said money, the plaintiff has no interest in the money other than for its charges and costs, which application is supported by an annexed affidavit of Philip Perio, the nature of the case and other reasons to be adduced at the hearing. This dated at Nairobi, this dash day of the obvious jurat and attestation, and you're serving upon the parties. If any part served does not appear at the time of this above mentioned, such order will be made and proceedings taken as the judge may think just and expedient. Then you have your affidavit, the Republic of Kenya in the High Court of Kenya at Nairobi, Milimani Law Courts, civil case number dash, West Bank of Africa Limited, the plaintiff versus the first, second, third, and fourth respondent. Affidavit I, Philip Oleterio of Wabera Streets, PO Box 30437, Nairobi, make all and say. And state as follows, maybe we shall just say state as follows or something. I am the manager, security services of the plaintiff hearing, and I'm duly authorized to make this affidavit on behalf of the plaintiff. The plaintiff has two bank accounts, number this and number this, in the names of the second and third defendants, respectively. On the 12th of April 2000, the plaintiff was served by the fourth defendant with a copy of an order made in the Chief Magistrate's Court at Nairobi in criminal case UWR 226 of 2000, restraining the plaintiff from allowing any withdrawal of or transfer of monies from the monies deposited in accounts, this and this number. A copy of the order is at pages 1 and 2 of the exhibit here too. On 17th April 2000, the plaintiff was served by the fourth defendant with a copy of an order made in the Chief Magistrate's Court at Nairobi in criminal case UWR 232 of 2000, restraining the plaintiff from allowing any withdrawal or transfer of monies from the monies deposited in the accounts, dash and dash. A copy of the order is annexed. On 30th May 2000, the plaintiff received a letter from the first defendant dated 26th May 2000 claiming control over the monies in the accounts. A copy of the letter is page 5 of the exhibit. On 14th July 2000, the plaintiff advocates PPP Kababa and PPP received from PPP and Company, the advocates for the first defendant, a copy of the order made by the High Court at Nairobi, Milimani Law Courts, in civil case PPP of 2000, restraining the second and third defendants from dealing with the monies in accounts, this and this. A copy of the order is at page 6, 7 of the exhibit here too. On 17th July 2000, the plaintiff received a letter from the second defendant claiming that the order in the High Court civil case PPP of 2000 superseded the orders made by the Chief Magistrate claiming access to the monies in his account. A copy of the letter is at page 8 of the exhibit. Plaintiff's advocates relied on 21st July 2000. A copy of the letter is at page 9 of the exhibit here too. On 31st July 2000, so he proceeds to give evidence, and exhibits all the way to paragraph 20. To paragraph 20. So that we now go ahead to say, in paragraph 19 we say, the plaintiff makes no claim to any monies in the accounts and for its charges and cost of these proceedings. There has been no collision between the plaintiff and any of the defendants. The plaintiff is willing to pay or transfer the monies into court or to dispose of the monies as the court may direct. I verily believe that this application is urgent as there have already been threats of contempt proceedings against the plaintiff. I now produce exhibit marked POP1. Save where otherwise stated, I make this affidavit from facts within my own knowledge and contained in the plaintiff's files. So you swear sworn by the said Philip Oleterio at Nairobi, before me, Commissioner for Oaths, drawn and found by, and to be served upon by. To be served upon parties. I'll share this link in a few.
Thank you, Ringera. So that was was a very good presentation, Ringera. We have also noted of another aspect where you should show there is no collusion between any of the parties, and that is a very good move. So remember, if you are doing an application and you are told by the examiner that the court is in recess or in vacation, the session is recorded. You can stop recording. You are not violating your. Okay. So let me go back to my presentation. Okay, I believe now mine is visible. Yes, Pluto.
Thank you, Victor. I wish to note some issues that are have arisen out of whatever Mr. Ringera has presented. I'm a bit concerned in as much as we're talking about substance of the form. There are some apparent errors that I've seen in that application. For instance, the issue of the caption we've already addressed. Then number two, originating someone is not an application. So I don't see how you can certify an originating someone or maybe seek an order for the same to be certified urgent. Then the way the orders have been framed, I'm also not agreeing with the same. My understanding is that an originating summon is only a request or is some way of instituting a civil suit, and what it requests is the determination of certain questions, not issuance of certain orders, unless you are asking consequential orders, something like after the end, now what the order that you need, after the questions have been answered. So I don't know whether that's just a technicality, but I don't understand how you can certify an originating summon as urgent. And number two, you frame it in seeking orders for, like framing it in more of an application rather than an originating summon, asking the determination of specific questions. I agree we are talking more about the substance of the form. So maybe you can talk about.
Maybe I can give a rejoinder in that. Remember, we have been told the court is in vacation, and rule number one: if the court is in vacation, you approach court using a certificate of urgency, pursuant to the rules of the court. Now, when it comes to the orders part, we can clearly also reason out with you that this is an application that strictly just wants to determine straightforward issues, and you cannot be begging court to give you orders that will require maybe determination or listening to the other party on factual grounds. Okay, so we greatly allow that, but what if there is a risk of dissipation of this right that you want to protect? Yes, Mr. Pluto.
I believe the best practice will be after filing the OS, you now come in with an application seeking maybe temporary orders or interlocutory orders for preservation of such, but you cannot certify an originating summon as urgent because an OS is basically a plaint in some way or another. Eco-classy applications. Classy application whereby OS inaweza ingia maybe a chamber summon and notice of motion. Those are the only application which you can certify or seek an order of the same to be certified urgent. So for on OS like this one, if I was the one drafting, I would have done the OS, then accompany it with an application seeking some urgent orders.
Now that application we should have now used chamber summons, right? Because we can now say that there is a pending suit. Yes, Mr. Martin?
I'm getting more and more confused. Pluto, what exactly are you guys saying in Brian? It's a bit confusing. You know why? You were saying, can you exactly tell us exactly what you're saying? I'm confused a bit. Are you saying that an OS cannot be done in a certificate of urgency or what?
I don't know, maybe I can go.
Okay. Yes, you can go, Pluto.
What I mean, Mr. Martin, is that an originating summon is basically a form of initiating a civil suit, whereby the issues are not contested as much, might not require viva voce evidence. That is a oral hearing. So instead of filing a plaint and you have accompanying documents like statements, blah blah blah, and then certify and set down the matter for hearing, you can just file an originating summons because the issues are very direct. For instance, you just want the court to determine whether respondent A is the owner of a particular vehicle or whether owner B is the owner of that particular vehicle. So in such instance, you are going in with the originating summons, which is supported by supporting affidavit. And here, evidence will be adduced in the form of supporting evidence. That is different from an application. Application, you are seeking particular orders. searches, assuming that there is a plaint which has been filed, maybe in EC court, then you get wind of information that maybe the defendant is in the process of constructing some particular buildings there, and that property is contested. You are going to file an application seeking interlocutory orders that the defendant respondent be restrained from continuing with constructions or anything related to that. So you see, that's an application aside from the originating summons. An application is basically you are seeking some interlocutory orders or some temporary orders that you need before now the main suit is tried. Now, as such, you can seek one of the orders that the application be certified urgent, because there is some urgency or something that might happen and you want to cure it. But for originating someone, treat it more as more of a plaint application, and as such, you cannot seek an order that the same be certified urgent unless you file an application. I don't know whether we are now on the same page.
Good. Thank you so much, Pluto, for that clarification. Yes,
So
Brian?
the clarification was on the one that we have just seen. You see, he was also bringing it under High Court vacation rules. So he was certifying it as urgent because the court is in recess,
And Pierre, maybe Pluto, you can also comment on, can you seek orders necessary for determination of the competing claims? Are you also prohibited from orders that are seeking any preservation for determination of the competing claims? Yani, kama utapewa hizo orders, yani ita defeat even this suit. Let me not call it an application. This suit being brought under originating summons.
Yes, my understanding is that under this subject to your corrections, all the members, you see, if there is an issue that should be determined before the hearing of the whole suit or the whole OS, my understanding is that you need to file an urgent application, an urgent and a certificate of urgency, an application and a certificate of urgency, sorry. Because in the OS, they are the question that you need the court to determine, which is basically your prayers. Now, if there is something urgent, you need to file a separate application, because ukiweka hapo, it means the whole OS must be heard for those orders to be given.
We have seen your rationale, Pluto. We are guided with it by it. So you are saying, if I wanted orders, this is a suit that have originated and originating summon, and because it is just for determination of simple and straightforward questions, let us not seek complicated orders from such. You just do a chamber summons and attach a certificate of urgency and seek the relevant orders that you'll be seeking, because nothing prohibits you from doing that. Let originating summon be as straightforward as much as possible. So that is how I can try to summarize your argument and also support Brian that we did a certificate of urgency because the court was in vacation or recess. Good. So I like those kind of arguments, so that wakati tunaingia kwa discovery and inspection, these are very ignored part, and it also featured in trial advocacy in one exam that we saw. Alafu pia it can also feature in civil litigation, because not many students know about the difference between the two and how you can draft the same and where do you draft it. So this one, I believe Pluto is a guru, because I have insider information. So discovery and inspection, the purpose of the same is that discovery ensures that parties disclose relevant material before trial so that neither side is ambushed and issues are narrowed, admissions may be made, unnecessary evidence is avoided, settlement is facilitated, and the hearing proceeds efficiently. So these are the marks for the 5 question marking points, where you are told by the examiner, give us the purpose of a discovery and inspection in civil litigation. So you tell the examiner that this is important before trial. It is conducted at the pre-trial conference, and it is primarily focusing on making sure that neither side is being ambushed. So you are avoiding trial by ambush, that you are making sure that the issues will be narrowed and admissions may be made at this time, and unnecessary evidence will be avoided, and settlement can be facilitated at this time, and that the hearing proceeds efficiently. Okay, so you can even be told to draft discovery questionnaire. Okay, not discovery questionnaire. Inaitangwaje Pluto hiyo kitu? Kuna questionnaire. Is it pre-trial questionnaire? Thank you. On the issues that you have even narrowed down pursuant to the pre-trial conference management, your stage. So the legal basis, you must note that it is provided under Section 22 of the Civil Procedure Act, Order 11 on case management, Order 16 on summonses to produce documents, Order 18 Rule 11 on court inspection, and Order 40 Rule 10 on detention, preservation, and inspection of property, and the provisions requiring parties to file lists and copies of documents with their pleadings. So that is the legal backing of this kind of an activity. So under Section 22, the court may make orders concerning interrogatories, admission of documents and facts, discovery, inspection, production, impounding, and return of evidentiary material. So the limits will be that the discovery will be limited by the following. What is the relevance of that kind of evidence? Proportionality, possession, custody, or control? Is it a document under the CID department? Is it a legal, professional, privilege protected document? Is the document having without prejudice privilege? Is there any public interest immunity to that document? Is there confidentiality and privacy arising? Is it a medical document that can disclose a medical condition and that it is irrelevant in this suit? What are the statutory restrictions and protection of trade secrets? Okay, those are the limitations where the court will tell you where the other party can also object to that production of that kind of document. Confidentiality alone does not necessarily defeat discovery. So the court may permit a redaction, restricted access, sealed filing, or inspection by advocates and experts only. So don't come and say this is merely confidential. You must have a basis. So how will you do a request for voluntary discovery? So at times the examiner can tell you, we are approaching the pre-trial conference and we have discovered that there is a document in possession of the other party, and that document is very vital, because if that document is provided before court, then the whole case will be determined in my favor. So it will be in your favor if that document is produced and it is in the custody of the respondent. So you write a letter for requesting for discovery and inspection. So you say, we act for this party and pursuant to Section 22 of the Civil Procedure Act, Order 11 of the Civil Procedure Rules, and Court's case management directions dated this day, kindly provide us within a number of days a list of all documents in your client's possession, custody, or control relating to a certain issue, and give us the copies of the document listed in Schedule Number A that you'll attach, and inspection of the original documents listed in Schedule B, and a written statement identifying any document withheld and the legal basis for withholding it. So the documents are relevant because you give now the brief explanation why you require those documents. If compliance is not relieved, our client will apply for appropriate orders and costs. So that is just an introductory letter. Basically, it is applicable both in trial advocacy and civil litigation in any way or another. So, Pluto, is there any, how will you approach court and tell court that, hey, look, I need to request for these documents from the other party? Do we file an application, or we say it orally during pre-trial conference management procedures?
Yeah, you mean when the adverse sides are document that want the same to produce? You just serve them with a notice to produce.
Okay, you serve them with a notice to produce.
Then you serve them and file affidavit and should adhere to that notice to produce.
Thank you. So my letter is scheduled in a way that it is also a notice. Ndivyo
No, it's not
sijaweka.
a letter. It's basically
Okay.
like something like a mention notice. Yani iko na caption, iko na the parties, everything, then notice to produce. Then kuna specific wording can't at the moment. Notice to produce. Like you write to them more of giving them a notice that you require these documents in court, so they should file the same or serve with the same.
I'm also looking
Which,
online.
an adverse determination will be made against them. That is, for instance, the court might be of the view that they are hiding a document which is against them.
Thank you, Pluto. I've also managed to look at what you are directly telling us. So you are telling us it is looking like this. It is being brought under Section 69 of the Evidence Act, Cap 80, and it is being addressed to the defendant's advocates. And you are telling them that take notice that you shall be required to produce the originals of all the documents relevant to this suit, which are in the defendant's possession or power, including papers, letters, memoranda, minutes, and all writings in particular. And now the examiner will be expecting you to list the item number, the date of that document, and even give a brief description, and you date it, then you sign off. Now, Pluto, that is the exact document, right?
Yes, yes.
Thank you so much. I'm trying as much as possible not to leave any gap in any kind of presentation, because we are in last minute, so it is better we deal with everything at once, so that now the next part inaingia kwa third party proceedings. Many students, even in orals, were confusing between third party proceedings, interpleader proceedings, and garnishee proceedings. So now we are at third party proceedings. Now, third party proceedings, the purpose of this is that a defendant may bring a third party into the suit where the defendant claims against that person. You are either claiming a contribution, indemnity, and you're telling the court that the relief is connected with the plaintiff's claim, and that substantially the same relief is being claimed by the plaintiff, or determination of a question related to the subject matter that should bind the parties is the one that is of dominance. So third party proceedings prevent a defendant from having to file a separate suit after being found liable. So take note, who is doing this kind of an application? It is a defendant. So the moment the examiner sees that you are doing this application as a plaintiff, automatically unaanguka tu roho safi. Unaona? So the defendant will bring this third party proceeding, and he will be seeking contribution, indemnity, or a relief connected to the plaintiff's claim, or substantially the same relief is the one being claimed by the plaintiff. So what is the procedure? Because you can a procedure under Rule 1, under Order 1, Rule 15 all the way to 22. The defendant applies ex parte for leave to issue a third party notice. Okay, that's the first step. And the application should ordinarily be made within 14 days after close of pleadings unless time is extended. So the affidavit must explain the nature and basis of the third party claim. And if leave is granted, the third party notice and pleadings will be served now to the party that you want to call as a third party. And now the third party will enter appearance, and the defendant will apply for third party directions, and the court determines how the claim will be tried and whether the third party is bound by the outcome. So the defendant must plead a recognizable claim for contribution, indemnity, or connected relief. It is insufficient merely to allege that the third party knows relevant facts. So you can't bring such kind of an application before court on grounds that the third party knows relevant facts. So these are the red herrings provisions that the factual matrix will lay before you, waone whether you know to what extent you bring this kind of an application. So we have said directly that you are doing an ex parte application for leave to issue that party notice. So ignore the angle of notice of motion because it is under chamber summons, unless hapo ninakosea. Pluto, can you do both ama one will suffice chamber summons?
Right process chamber summons.
Thank you. But if a student, okay, hii ni CLE, wacha tusingie hiyo angle. It is being brought under Order 1, Rule 15 all the way to 22, and the defendant will be seeking orders that you're seeking leave to be granted to issue and serve a third party notice upon a certain person. And the annexed draft third party notice be approved. So you have even attached a third party. So you have even drafted a third party notice in this kind of application. So I know why I wrote that way. Ni juu hapo chini tutahitaji notice of motion. So it is chamber summons and notice of motion for this kind of applications. So you are seeking leave for the court to allow you to be granted and serve a third party notice, and because you want to save the court's judicial time, you have even attached or annexed the third party notice, and that the defendant be permitted to serve the notice together with the plaintiff, defense, and relevant pleadings within 14 days, and cost being the cause. And the grounds that the examiner will be looking at, whether you know what entails for this kind of an application. You are saying that the plaintiff claims, you summarize the claim, and that the defendant has denied liability, now you being the defendant, and that if the defendant is found liable, the proposed third party is liable to indemnify or contribute because there is a contract between us, he has conducted a negligence angle, there is a statutory duty that he has or other basis, and that for the proposed claim arises from the same transaction or occurrence, and that determination in the same proceedings will avoid multiplicity of suits, and that this application has been made within time, and that delay, if there is any delay, you explain the same. So at times the examiner will tell you to draft the necessary notice to accompany this kind of a chamber summon application. So the notice will be addressed to somebody, and take notice that this action has been brought by the plaintiff against the defendant. You summarize the relief, and that the defendant now claims against you either to indemnify him in respect of any sum the defendant may be ordered to pay by the plaintiff, to pay to the plaintiff by the court. I'm also seeking contribution in the proportion of this amount, and connected relief and cost. And the basis of the claim is that on this date you entered into a contract with me, you performed work, you assumed duty under clause this, you are required to do this, you breached that obligation, and now the plaintiff claim arises from that breach or omission, and consequently if the defendant is found liable, you are liable to indemnify or contribute. You are required to enter appearance within the period stated in this notice, failing which you will be bound by the judgment and such further orders as the court considers appropriate. So when you're told to draft a third party notice, don't draft a third party notice on grounds that you are just giving a notice. Take note of the meat of that third party notice, because you are more likely to draft and bear third party notice without the meat. So you are giving a notice, you are giving the brief prayers that you will be seeking, the orders that you will be seeking against that third party, and what is the basis of the claim. So if you don't have a basis of the claim that I can read it prima facie, then automatically your third party notice will not have the meat. Then after the leave has been granted, you now approach court using a notice of motion, and now you will adequately capture order 51 of the civil procedure rules directly, and order 1 rule 15 all the way to 22 on now the notice of motion part of it, addressing it in details. So those are the nitty-gritties that I wanted to lay out before you, so that you appreciate. So have a distinction between a third party notice and an interpleader on the other side that we looked at under order 34. So maana hizi vitu sasa zimeanza kukua sasa obvious, and that is the rationale. Now at times, remember in our session pale juu tulisema disposal of suits by summary procedure is different from an application to strike out a plaint. Okay, so let us start with disposal of suits by summary procedure. You can be told by the examiner that there is somebody or a claimant. Okay, before nianze overthink, let us read the purpose of summary judgment procedures. So take note that this is provided under order 36 of the civil procedure rules. And the purpose of this is that summary judgment allows a plaintiff to obtain judgment without a full trial where the defendant has no bona fide defense. So take note, enter appearance, akaweka defense or hiyo defense sasa ikapatikana haina any meat ama hajaweka defense, okay, inaweza kuwa ndani. Okay, kuna default of appearance. Pluto, you are a guru here. Pluto, unaweza tuambia the difference between a default judgment, a summary procedure, or the nitty-gritties that we should know before doing such kind of an application. Hapa kuna maneno kwa hii summary procedure.
Give it a before summary judgment and interlocutory judgment. 10, that is default judgment. That is for judgment in default. Defendant has failed to enter appearance within the prescribed time. Or number 2, has entered appearance but filed no defense. So basically, there is no defense, there is no appearance, make an application for default. Or 6, I believe, summary judgment. That's a judgment which is entered when entered appearance, defense, the defense raises no trial issues. The defense has just the defense playing has the same. So usually you need to deny complaint, then traverse them. Denying simply means denying that and on the other side to raise an issue by traversing something, saying it was this way, this like reading defense because it doesn't raise any tribal issue. Is the defense failed to or that not subject to the claim under to prove their think this way is a traffic contain as soon as the vehicle drive defender here. One, the issue of liability. Two, the over damages. And 3, there is issue of special damage. Then, for the ability judgment in for damages there will be looked on general damages awaiting more providing the court to assign the correct amount that should have paid. And 3, the special damages report to be distributed. Leave 3 aspects.
Thank you. Mr. Martin? Oh, ni Mr. Brian.
In addition to some the prayers to be fulfilled recovery of land or rents for land.
Thank you so much, Brian. Mr. Chedwick? Thank you, Chadwick. Mr. Martin, your hand is up. Okay. So I wanted that kind of a distinction so that wakati sasa tuna discuss summary procedure to say confuse. So summary judgment is under order 36, and the summary judgment allows a plaintiff to obtain judgment without a full trial where the defendant has no bona fide defense. So qualifying claims, that's why Ringera ametuambia at times the examiner can twist the question. So do you know where exactly you will do a summary judgment? It principally applies to a liquidated demand with or without interest and a recovery of land. Hapa sasa kuwa keen. Where a landlord from a tenant whose term has expired or been determined. 2. A landlord after forfeiture for non-payment or breach. 3. A claimant against person claiming under the tenant or a claimant against a trespasser. Okay, so when you see the factual matrix inclined towards a landlord from a tenant whose term has expired, a landlord after forfeiture for non-payment or breach, a claimant against persons claiming under the tenant, or a claimant against a trespasser, now umeanza kujua where exactly you can claim apart from a liquidated demand. And a liquidated demand is an unascertained sum or other ascertainable by arithmetic, or one ascertainable by arithmetic without factual investigation or judicial assessment. So that is the definition of a liquidated demand that Pluto was talking about. So it is ascertained directly. If you do the sums inakuja direct, this is a special damage done, it's a liquidated demand. But where itahitaji factual investigation or judicial assessment kama general damages, that's where Pluto anatuambia that will have to go for formal proof. So claims for general damages are ordinarily unliquidated and unsuitable for summary judgment. Okay, so the application, so the procedure is that this application is made after the defendant has entered appearance. It must be supported by an affidavit verifying the cause of action and about being claimed. It must give the defendant at least 7 days notice. It may result in full or partial judgment and may result in unconditional or conditional leave to defend. If the defendant raises even one bona fide trouble issue, unconditional leave to defend should ordinarily be granted. A trouble issue need not ultimately succeed. It must merely merit trial. Okay, even one trouble issue will make your application to fail. So the application for summary judgment, yes, Mr. Pluto?
Just question.
Yes. Okay. Mr. Martin Bado, your hand is up. Okay, so you'll bring this kind of an application using notice of motion, and you are bringing it under Order 36, Rule 1, 5, and 6, and Order 51 of the Civil Procedure Rules. And the plaintiff will be seeking orders that a summary judgment be entered against the defendant for this amount, interest be awarded at this amount until payment in full, alternatively judgment be entered for the admitted or undefended portion, this amount, the defendant's counterclaim, if any, proceeds separately and without staying execution unless the court orders otherwise, and cost be awarded to the plaintiff. So the grounds that you'll be seeking before you will be stating to the examiner is that the claim is a liquidated demand arising from either a contract, an invoice, or acknowledgement that the defendant entered appearance on this date, that the debt became due on this date, the amount is ascertainable by simple arithmetic, the defendant admitted the debt using a certain letter or email, or no bona fide trouble issue has been disclosed, and any denial is bare, evasive, or unsupported by the contemporaneous documents. So you do a verifying, is it verifying or supporting? Supporting affidavit. So the affidavit should verify the agreement, identify performance by the plaintiff, set out the calculation, attach invoices and delivery evidence, identify the due date, attach demands and admission, and state why the defense is a sham or raises no trouble issue. Pluto, do you do verifying or supporting? Isikuwe naongeza zangu.
or a state or in
Good. You had a question.
judgment, and then one also postponement
Okay, there is form 13A in the civil procedure yenye inasema you do that when requesting for interlocutory and even default judgment. And now for summary judgment you do an application under order 36 rule 1 now for CLE purposes. And now when you are doing striking out of a defense, see that unaifanya under order 2 rule 15 thereabout ya ku strike out a plaint, not a defense, a plaint. Unaona? So the defendant ndiye anafanyanga application to strike out a pleading, okay, under order 2, and I invoke the court's jurisdiction to strike out a pleading. But now when it comes to summary judgment, who is doing it? It is the plaintiff, and attack the defense by the defendant. Mr. Pluto, hiyo inaweza kuwa inajaribu kujibu.
that any party can make an application for striking out things for the defendant. And for summary judgment, I believe that you can do an application for some which
Thank you. Before your screen sasa ni striking out of suits or pleadings. And maybe we can brush it through, we see exactly kama kuna any application to be done. Kuna application to strike out a plaint. Okay, let us see what it is saying. So striking out of suits or pleadings, the legal basis will be under order 2 rule 15, where the court may strike out or amend a pleading where it discloses no reasonable cause of action or defense, is scandalous, frivolous, or vexatious, may prejudice, embarrass, or delay a fair trial, or is otherwise an abuse of the court process. And the power applies to plaints, defenses, counterclaims, originating summons, and petitions so far as applicable. So the evidence rule is that where the application relies solely on order 2 rule 15 1a, no reasonable cause of action or defense, no evidence is admissible, and the court examines the pleading itself. So evidence may be used for the other limbs, but the application should identify the exact ground and avoid improperly mixing affidavit evidence into a rule 15.1a challenge. So the threshold is that striking out is a drastic and should be exercised sparingly. Pursuant to the DTWB decision, a suit should not be struck out if amendment can cure the defect, factual questions require evidence, the pleading raises a bona fide issue, or the claim is not plainly hopeless. So that is for striking out of suit, so that we see the application for striking out a plaint is being brought under notice of motion under order 2 rule 15 1a, b, and c, and d, and order 51 and section 1a, 1b, 3a of the Civil Procedure Act, where the defendant seeks orders that the plaint dated this day be struck out, the suit be dismissed, or appropriate consequential order that you want the court to issue you, and alternatively the impugned paragraphs be struck out and the plaintiff be directed to amend within 14 days because you are even trying to save time. And the possible grounds that you can tell court is that the plaintiff discloses no reasonable cause of action because of this day, this, and this. The pleaded facts, even if accepted as true, do not establish breach, duty, etc. The claim is barred by res judicata under section 7 of the Civil Procedure Act. The suit is a collateral attack upon identified final judgment. The plaintiff lacks legal capacity to institute the suit. the suit duplicates a certain case number and constitutes an abuse of court process, and the pleading is scandalous, frivolous, or vexatious because of this and this, the defect is incurable by amendment. If relying only on no reasonable cause of action, do not file or rely upon evidence. So basically Pluto tunaona ni kama mnaweza fanya application for CLE purposes, and we also have other summary disposal mechanisms, and this is also seen under a judgment on admission under Order 13 Rule 2, where a party may seek judgment based on a clear unequivocal admission in either pleading, correspondence, affidavit, recorded negotiations not protected by privilege, or other admissible material, and this admission must be plain and unambiguous. So take note, si kila mahali unaenda una strike off a suit or even seeking summary dismissal. While there is a judgment on admission, you clearly approach court using Order 13 Rule 2. Another way to summarily dismiss a matter is through preliminary points of law. The court may determine a pure legal issue capable of disposing of the suit, provided the material facts are not contested and no evidence will be required. Then we also have interpleader summary determination. Under Order 34 Rule 5, the court may, with consent or at a claimant's request, determine competing claims summarily, while the nature and value of the subject matter make that cause appropriate. So with that, we have discussed the nitty-gritties of how you will do an application to that effect. Unless sasa Pluto you had something ama any other member, isikuwa nimefungia mtu. So at times you can be put on your feet to reply, to make a reference to striking out an application. You are now told you are acting for the plaintiff whose plaint is about to be struck off. Now make the relevant response to it. So you will make a ground of opposition where the plaintiff will oppose the application because the plaintiff discloses an arguable and legally recognizable cause of action, where the application raises contested factual matters requiring evidence at trial, and the defendant improperly relies on affidavit evidence under Order 2 Rule 15(1). The pleading raises serious questions concerning certain things. Any defect is curable by amendment, and that the application invites the court to conduct a mini trial, and striking out will disproportionately deny the plaintiff a hearing on the merits. And that is the case that the application does not meet the threshold in DT Dobie and Company, Kenya Limited versus Mushina. So you can read that decision in its entirety so that you can appreciate how it is applicable. So ingine ni vacation application. Let me see kama kuna kwanza major application. You can see if you are doing an application under recess, or during recess you usually do a certificate of urgency, then you do that kind of the application that you want. So let us kwanza tuangalie kama kuna landmark applications badala ya kuingia kwa the niti zenye zimejificha zenye examiner zifikiria kwanza. Hii ni gani? Formal application for leave to appeal. This one is a huge one. Oral application for leave. Application for leave to amend. Okay, let me brush the, okay, hata nimefika mwisho. So formal application for leave to amend. Okay, by the way, you can be told that a judgment has been rendered, then now you are required to do a formal application for leave to appeal. But before doing that, you can give the oral application for leave to appeal, then now retire down to do the formal application for leave to appeal. So the opening statement for this kind of an oral application for leave to appeal, immediately after judgment has been rendered, you will be telling court that Your Honor, the applicant seeks leave to appeal against the ruling delivered today under Section 75 of the Civil Procedure Act and Order 43 Rule 1, 2, and 3 of the Civil Procedure Rules, that the proposed appeal raises an arguable question of law concerning certain thing or issue. The point is not frivolous and its determination will materially affect the future conduct or outcome of the proceedings. We also pray for certified copies of the proceedings, ruling and order, and for temporary stay of this and this to enable the applicant to approach the appellate court. We are prepared to comply with reasonable terms as to security. So take note that this is more likely to be asked in a trial advocacy paper as compared to a civil litigation paper, because for civil litigation you will be told now to draft the appropriate application to secure the appeal. So take note that we also distinguish between, there is a different webinar where okay, we have not yet presented, I will notify you. Civil appeal applications ikiwa kando, kuna criminal appeal applications zikiwa kando, where we have even mentioned something to do with 52B, why it is confusing, okay. Then criminal side of it, where do you use petition, etc. Kuna nitty-gritties where students usually ignore because si kupenda kwao, it is because they have not been exposed to the practical aspect of it. So when doing a formal application for leave to appeal, so like for this one is being brought under section 75 of the Civil Procedure Act, maybe a person can open so that tujue alikuwa na appeal against which kind of an application etc. And order 43 rule 1. So the applicant will be seeking orders that leave be granted to appeal against the ruling dated this day. The next draft memorandum of appeal be deemed duly filed upon payment of fees. Pending the intended appeal, execution be stayed. Certified proceedings, ruling and order be supplied, because we seek stay because appeal in itself does not grant you a stay order, and that the grounds is that the impugned decision concerns this. The intended appeal raises the following arguable questions. The application has been brought within 14 days. Refusal of leave may cause prejudice, and the respondent will not suffer irredeemable prejudice. So application for leave to amend. Okay, so basically mambo ya appeal, don't worry so much, because I've not delved into the details of it. I've not even shown you how you distinguish between order 42 rule 6 and vis-a-vis how to do a 52B application. 52B application iliulizwa this year April, and appeal pending bail, okay, appeal pending bail application was required in criminal litigation, as it was also required in 2023 paper yenye nimefanya leo. So take note of how we have now started to master the procedures. Yani zimeanza kukua automatic. Yes, Mr. Chedwick. Oh. Hey, sorry, thank you for that. Thank you. So hiyo ni criminal part of it. Civil pia, watch out for those webinars. So maybe sasa hii ni wapige tu ka story of a mistake that I did in practice when doing certain applications, alafu what I did maybe to correct them, okay? So that hizi story utazisahau. One mistake that I ever did, I did an application and a notice of motion, alafu in the supporting affidavit we annexed the annexures, alafu nikasahau kupatia wakili aweze commission aweze kuweka ile stamp ya annex, because if you read a supporting affidavit ina mark kitu kama Brian Kimathi annexure 1, so BK1, so unafaa uchukue hiyo annexing stamp unadunga kwa ile karatasi to indicate as much. So with that application was uploaded in the CTS without the advocate commissioning the same. So ikakuwa shida, because ukiangalia decisions zinasema, kwanza niliambiango the other party wame counter that kind of an application on grounds that haina footing before law. So nikaambiwa now look for decisions zenye zitakutoa kwa that kind of a mess, okay? Juu imelipiwa hata 2000, so automatically mpaka kitu ulikuwa una pray for time imelapse, client amejam. Now nikiangalia decisions zinasema when you fail to annex evidence to a supporting affidavit, that application has no, haina miguu. Kwanza even judges wengi sana wamesema kitu, the application has no legs before the law, and how you can remedy that is through the discretion of the court. You pray for the discretion of the court to allow to do yani usiseme mambo ya technicality hapa, hiyo ni fatal mistakes that you will never do in practice, so never forget that. Nikafanya ingine ya huyu jamaa alikuwa anachotwa, so auctioneer amefika kwake, need objector proceedings. So hiyo iko part 2 of the civil application. So objector proceedings, okay, so nika identify because nikasema auctioneer amekuja kwa mlango, now ameproclaim this lady's items, and now I'm being told to do the good application, nikachukua objector proceedings. Now the mistake that I did is that among the goods that were proclaimed, one of the item, in fact it was a vehicle, motor vehicle, was not belonging to the lady. It was belonging to the husband. So okay, not the husband, it was belonging to a person who had already bought that car. Already alikuwa na transfer, form of transfer. So when I was doing this application, mimi nasema hizi vitu zote zimewekwa hapa zina belong to the lady. Now let me do an application maybe to seek for summary payment of nini. So along that line nikaulizwa, did you ever do a search of this motor vehicle to identify whether it was registered in the name of the lady? So if we did a search, inatokea jina ni mtu mwingine, the buyer. So na huyu buyer anashindwa, manze, gari yangu inaenda kuchotwa aje? Option amenikujia, anataka kuchukua gari yangu. Kwani what is going on? So if you do an objector proceeding, you now tell court, look, now who is objecting? Mwenye alinunua ile gari ndio anakuja na object, anasema this car belongs to me, anaambia sasa hivyo court. So automatically the auctioneer should not proclaim something that belongs to another person. So now ukifanya objector proceeding, the court itatoa your property from that suit, alafu ikwe imepass off to that person. So those are the stories zenye tutakuwa tuna make, mistakes zenye umefanya, and then we know how to cure them, because in this kind of applications ni pote tuna have conversations sana hapo kwa appeals, civil, vis-a-vis, criminal, na unatoka magistrate, high court, court of appeal, supreme court. Okay, tumeona pia jurisdictions ikichange when it comes to succession matters, where you can now appeal direct to some place or other jurisdiction. What if CLE chukua hiyo case lo ilete direct kwetu, alafu unakimbilia unasema there is a limitation on this without considering the changes of the law of that procedure. So iko to conversational and through mistakes. So mimi nimemaliza this session. This is session A on civil applications. These were main applications, bado tujamaliza, we will proceed on. Alafu sasa sasa inaona time imerun, it is 10:47 p.m. My intended webinar number 2 ilikuwa extradition procedure, where nime dissect all confusing procedures in extradition process. So hiyo ni late night birds when watagojea to take a short break, then we resume hapo. Muna suggest saa ngapi wenye sasa huwa tunafanya mpaka ile masaa yetu? Or I end first. Let me end first this recording. Ama kwanza, before I end, do you have any comment, any areas to improve, any suggestion that you want me to consider?
You know that after the defense has issued a counterclaim, then they might mention in passing in the counterclaim, but they now need to now do that party notices and such. Can you just do a recap?
A recap is, Pluto, will you be in a position? The reason why I'm in a position to identify the strength of a person is because kuna venye unaonanga tu mtu, even how they answer questions, unasema this one, kama Brian, I have already identified you in a commercial paper, you can't fail to score above 60, because one thing, hiyo ni kitu area moja una practice. In my view, because I practice not practice wewe, I'm under an advocate on conveyancing, hiyo unit najua siwezi anguka, unaona. So kuna some units kama Pluto civil, because I know ako under a senior on civil, Mr. Chedwick, Mr. Martin, kila mtu, there is Madam Rosa, kila mtu kuna that aspect yenye ana carry along with him or her yenye iko very unique to nini. Pia mimi professional ethics, Pluto can attest, nimekuwa kama a respondent in various complaints za kuenda wapi ADT, SEC. I've also mastered the art of professional ethics on that aspect of it. So kuna hizo aspects zenye unaweza pia carry along your field of learning. Okay, so maybe Pluto, do you have any way of you can summarize a third party proceeding isichanganye Brian aende afanye garnishi proceeding?
So to bring it home, third party proceedings are basically goes to court seeking damages because you have negligently lost that claiming that you are liable for causing that accident, because if it were them to hit, you would have them out of that case. That party, I believe we are together up to that involved in any way. Therefore, because it's not the business of the plaintiff to know will pay me or will compensate me, they provide proposed party. Liable
So please. other
If at all an accident occurred, are not liable, and instead act or you agree.
issue at that party.
The question here is not
Thank you, Pluto, for clarifying towards Brian. And even Brian, if you read the last statement on your screen, the defendant, you Kwanza, you must plead a recognizable claim for contribution, indemnity or connected relief. Kwanza ujitoe na kuonesha you have a recognizable claim for that. So it is insufficient kunitaja kama victor na uambie court that hey look, it is victor and anajua kitu ili happen. That will be insufficient before the court as a defendant to say. Yeah. So yes, Mr. Chadwick.
The third party has been brought, and can the third party apply for the suit to be struck out on under Order 2, Rule 5? Rule 15.
In my view, nothing stops any party from doing an application to strike off if it is scandalous. Okay, so kama atakuwa in a position to do that, anaweza fanya. I hope you're not confusing with an interested party, because I know that route ndo unataka kwenda, because an interested party now will not be involved in the intricacies, right, Pluto? Can an interested party go into the intricacies of a matter?
To use it or to ignore it?
Pluto? Okay. We will also do further research. Mr. Chedik, alafu pia Pluto clarify on interested parties, what are their limitations? Good. So remember, Brian, what you said in the last meeting. Whenever we have two conflicting procedures, we note them down, then we clarify with evidence or legal positions. So now, Pluto, could you identify that is a tug of war on that issue? We'll clarify. Then the other issue that I also expect to be clarified is there any limitation of what an interested party can and cannot do in a matter?
That, but they can't file a defense because the plaintiff.
Thank you so much. I also read that decision. It's something to do with church. Just church something. Masawa, it's a Supreme Court decision. Mr. Chodik, you are saying something. Thank you so much, members. So hapa sasa ndio session inafika mwisho, inafika tamati, unless there is another member kuna say before I close off. So tuko tu tunadandia, because if you are keen, from our past meeting we made some resolutions. We stole time, class attendance, because people will be logging in, then they will be listening to the class attendances during the course of the day, but hii itakuwa for watu wanataka tu kufanya hivyo. Alafu from 8:15 to 10 p.m. another paper, and we decided that in every session that we do, we purpose to finish a paper, so that to minimize various divisions of a paper zinapotea hiyo track. Then we limit the attempt of one student against the marking scheme. Then we allow many discussions on whether the marking points reflect to what the examiner wanted. So discussions on what the examiner wanted ikuwe mingi as compared to listening various stories on a student trying to answer a question. That's why we have limited one question to a student. So to avoid ambush, tukasema I will be disclosing kama next week we are doing 2023 sets of March. So we will be prepared for 2023 sets. Now we will do all the sets from Monday to Friday, because in the morning hiyo 4 am to 6 am tukaweka webinar sessions like these ones. So we will be discussing procedures from 4 am to 6 am because it allow a lot of discussions, clarifications. We tap on various knowledge of everyone. So yes, Mr. Chadwick.
Okay. And we respond, and then you gauge us against the marking scheme. It's a good approach because
Thank you so much, Mr. Chadwick, for that feedback. So at least now, when I've introduced webinars, avoid a situation where we discovered a challenge when we were doing past papers, and then we never discussed that challenge in details, because wakati tulipitia financial system questions, there was a difficulty from students trying to answer that kind of a question. That's why we did sasa tumeweka webinar, tuta present uzuri asubuhi. Financial system, we do the notes, then there are question and answers, because now you'll connect the dots why we did the notes first, then these are the question and answers. Then after that we can we have linked the question and answers vis-a-vis pia the Data Protection Act, because financial payment systems iko na angle ya kupeana loans alafu pia inaangalia ile angle ya data protection. So how will you merge between the two alafu ikuwe an effective paper? So at least I can say we are starting now to do a milestone. We have 2 months left. Now this will work magic, because nikisikiza hata class ya leo ya franchise agreements, nikikumbuka we did a question where we drafted a franchise agreement. Automatically I only know the elements of a franchise agreement, then I've already spared those hours. So hivyo ndo sasa at least tumeanza ku identify various areas za ku put more emphasis na pattern. So let us say, in fact, this is the only time in sasa usi break hii circle. If you miss to attend, make sure even recordings unasikiza tu, because mi naona we are going to the exact details of what CLE will require from a student. So remember, we have declared we must finish all the paper sets within 1 month. Then the other month ikuwe reserved for general knowledge, general laws zenye zina govern various units kama land laws, nini zote tuna analyze to. It will be beneficial if we just give commentaries of those legislations and moving matters arising in those legislations. So I also appreciate your consistent efforts, and let's keep the fire burning. Let's keep the fire burning. Sundays inakuanga free day, even hii Saturday sijui mnasemaje, nani ako willing kuendelea? Mimi uniambie tu timeline. Remember nilisema kitu moja from my end, because I've done the research. Okay, sitaki kuwa in a position where I did this research alafu nikanyamazia from presentation. Let you provoke me to present this knowledge. You know, extradition kuna mistakes to avoid when drafting a charge sheet. Imagine I have mistakes that wanafunzi wamefanya for drafting a charge sheet, inakuja 122 pages. So how sure are you hauwezi fanya mistake imekuwa captured kwa hiyo document? Unaona? So those are the nitty-gritties that we want us to have a look at. You just give me time indications. Mimi nipigie hata anytime, mimi naamka manze naingia session. Yeah. So Mr. Chedwick. Thank you, Mr. Chedwick. That is well captured. No room for postponements. Okay, so any other suggestion? Mimi naona the session is okay. So kama mko amenable, type pale group, nipe time allocation, mimi niko ready usiku. I'm still finalizing on the 2023 papers. Nikwambia inachukua full day hizi set mzima. Na bado nilianza over the week, so inachukua time. Kwa hivyo rahisi. So if there is no other suggestion, we will now end the session. Watu wasikiza hizo recording as much as possible. Jipia mimi nilikuwa nasikiza Sopec venye ninarealize hadi nashtuka mse. Sema pia nilisema walai. Na pia mimi my own recordings zinanishtua. So let us do quick recaps, tunaangalia tutakuwa perfect. Thank you so much.